My name is Nate Meyer. I'm a partner at Jaberg Wilk. One of my practice areas is insurance, including insurance coverage advice and litigation, insurance bad faith advice and litigation, and insurance UM/UIM litigation. A Helme Agreement is another settlement between a plaintiff and insured. In this context, what has happened is the insurance company, for whatever reason, maybe a good reason, maybe a bad reason, has rejected a settlement offer within the insured's policy limits. So again, just like a Morris agreement and a Damron agreement, the insured agrees to stipulate to some judgment against him or herself, assign any rights that the insured has against its insurance company to the plaintiff. The plaintiff signs a covenant not to execute that judgment personally against the insured. A Helme Agreement is based kind of on the third duty that an insurance company owes its policyholder. Insurers generally owe their policyholders three duties: the duty to defend, the duty to indemnify, i.e. pay any judgment that is ultimately entered against one of its insureds, and three is kind of an implied duty to give settlement offers equal consideration. You need to give equal consideration to the interests of both the policyholder and the insurance company. If an insurance company declines a settlement offer within the insured's policy limits, which would obviously protect the insured from any kind of personal exposure above their policy limits, then an insured can go ahead and enter that Helme Agreement. The rationale is that there has been a breach of that duty, of that implied duty to give settlement offers equal consideration, and therefore again the insured is liberated from the cooperation clause and they can enter a reasonable settlement to protect themselves from personal liability. Similar to an insurer's defenses to a Morris agreement, again you have notice, you have coverage, you have reasonableness of not only the stipulated judgment amount, but also whether it was reasonable for the insurer to reject that offer, that settlement offer within policy limits, and then again you have fraud and collusion. Regarding notice, the same facts applied as they did for the Morris agreement. You need to have a reasonable notice that the insurance company that the insured is going to enter that type of agreement. Regarding coverage, again, if the claim was not covered, then there's not going to be an enforceable Helme Agreement. Regarding reasonableness of the rejection of the settlement offer of policy limits, again, you're going to get a chance in a reasonableness hearing to prove whether or not that was a reasonable rejection. And then the same defenses applies regarding fraud and collusion. Again, very high standard, usually going to have the insured perjuring him or herself or some sort of sham proceeding. Very similar to a Morris agreement. If your insured enters a Helme Agreement, then what you're going to do, again, is you're going to want to move to intervene in the litigation between the plaintiff and your insured. You're going to want to try to stay that litigation while you can litigate the dispositive issues such as notice and coverage. If you lose on those dispositive issues, then you're going to want to prepare to contest both the reasonableness of the rejection of the offer to settle within policy limits, the reasonableness of the stipulated judgment in a reasonableness hearing, and then if you lose on both of those, then you'd also have the issue of fraud and collusion. And again, you should be able to do that in the actual litigation itself through a motion to intervene. If for whatever reason the insured and the plaintiff do not request a reasonableness hearing in the original litigation, then you're entitled to litigate those issues in a declaratory judgment action.